Yes! Hello, my beautiful friends. What an amazing day it is. We've got a guilty verdict. Judge Dugan, the backdoor judge, guilty on a felony count. She had 2 charges. One of those she got acquitted on, but the big one, she is busted, baby. So we have a great live stream planned ahead. We're going to go through the latest on that. I've got the recap from what went down yesterday. As we were wrapping it up, we here have been covering all of the transcripts, courtesy of the media that we've been reading through best we can to reassemble what's going on in the courtroom. Last night, the jury stayed way late and they came back with a verdict. So there were a couple of jury questions that got dropped. We'll go through those and really, I think, piece together why the verdict came down the way that it did. The judge gave a couple of instructions, one very helpful for Doogie, the other not so helpful for her, and the verdict came down accordingly. So we'll go through that. We'll brief what happened. We got reaction from Pam Bondi. Todd Blanche was out. I think Kash Patel we got queued up here today. And we'll see what the consequences of this whole thing might be, because it's 5 years in prison, baby. And as they told us for a long time, no one's above the law. But Dugan's team has come out, and they're, of course, going to appeal it. And they've got a whole strategy that they'll unveil for us. So we'll go through all of that coming up. Then, today's the day for the Maxwell release. We had a comment from our friend John yesterday. I was like, the hell are you talking about yesterday? Anyways, the files are supposed to be dropped today, and Todd Blanche said that they will, that they'll be coming out probably later tonight. They have until the end of the day, so I would not be surprised if we got like an 11 p.m. drop, because I've seen some other stories that they are scrambling to get these redactions completed. Hundreds of thousands of pages of files, bunch of names in there. So they're going through to redact a bunch of things. We'll see what Todd Blanche says about that coming up. And we'll go through Ghislaine Maxwell's petition for a writ of habeas corpus. She wants to get out, and she is representing herself now. No lawyers on this one. And she just sent this in, and it's pretty good for her. I mean, writing herself, I'm not sure if she actually did it or if her lawyer just gave it to her and said, file this on your own so that we don't have to be associated with it. But she assembled this. It is a big filing, and it's her petition saying a lot of stuff has come out since these government investigations from Congress and the DOJ have been underway. She's got new information that she says justifies her release. So we'll see what she has to say about all of that. Today's a big Maxwell Epstein day. We'll see what gets dropped, and maybe it'll get dropped while we're here together. We'll see. All right, so we got that. Then we got to talk about the Somali fraud situation, because apparently it was just like tens of millions originally. Like, wow, that's a lot. Then it became hundreds of millions. Now it is in the billions. $9 billion, which is, according to the prosecutor out there, over half of the money that went out. Billions, 9 billion with the B. Like Zelensky's like, dang, that's impressive. Wow. And it's true. It's insane. It's shocking. We've got the indictment queued up. More people were indicted over there. This guy, Hassan Ahmed Hussein and Ahmed Abdira Mohammed, now indicted, age 28, 27. They were stealing millions of dollars. We've got the indictment queued up. We've got the prosecutor's reaction queued up and more. And so it's going to be a beautiful stream, my friends. Thanks for being here and joining us. Thanks for subscribing if you haven't already done that. And Merry Christmas. Happy holidays. All the things. I hope you're doing great right now. It's December 19th, just days away from the big day. And so we're excited to be here. Early show today. Members, stick around. We'll do an after party today. And then members, we'll be back tomorrow morning for our Saturday members only stream. Thank you for supporting us by becoming a member and helping to enable this show. We're grateful for you. So we will have a great after party, and we'll be back tomorrow, Saturday, for a members stream. And then we are planning on being here next week, Monday, Tuesday, probably. Then we're traveling a little bit, and so the schedule will change from there. But probably early streams Monday, Tuesday, just a little schedule update and housekeeping order there. So, all right, now let's get to it, because we got some big news on the day. Judge Dugan found guilty. Felony count of obstruction. Not good news for her. We're going to go through the latest and see what the jury did when they were deliberating late last night. But it was a split verdict. She got acquitted on another count. It was the misdemeanor count for concealing the illegal alien that she let use her back door should have been guilties across the board, but the jury instructions that came down from the judge were a little bit squirrely. And so you can see kind of what happened here in a minute with those jury instructions and why the jury came down and acquitted her on the other count. But the big one, the felony count, busted. And let's refresh our recollection just so we can be very clear on what she got convicted of. You can see here, this was the original indictment filed back in May of this year. And we've been following this for quite some time, covered all the pretrial stuff, covered the trial. And it was a short trial, basically. This week, it was in and out. We heard from a bunch of judges. Some judges were on Team Doogie. Some other judges were on Team Government, kind of, very begrudgingly. They're like, okay, yes, what she did was wrong. Yes, I hate ICE. Yes, I love illegal aliens, but this was illegal. So we went through all of that. Now, count one, for which she was acquitted, was about the concealment of the illegal alien. Did she knowingly conceal this illegal called EFR out her back door so she could prevent the discovery and the arrest of this guy? Okay. Jury came back and said, no, not guilty for that. But if you look this up at section 1071, that's a misdemeanor. Okay. So that kind of stinks, but this was the big one. This is count 2. And the grand jury in this indictment said there was probable cause, but now the jury of the trial found that she is guilty. They said that Hannah Doogie did corruptly endeavor to influence, obstruct, or impede the due and proper administration of the law. ICE agents were there. They had an administrative warrant. They were allowed to do everything that they did, and she obstructed. There was a pending proceeding. We'll come back to that because of the jury instructions. It was being had before a department, Homeland, and agency of the United States. They were administratively arresting this illegal for removal proceedings under Homeland. And this is what this judge did. She confronted members of ICE, falsely telling them they needed a judicial warrant. She learned that they had an administrative warrant and then directed them to leave the location of the planned arrest and go back to the chief judge's office, who was also basically begrudgingly complicit in the prosecution, but was assisting her in avoiding any incriminating evidence. The judge, Chief Judge Carl Ashley, was calling her after this arrest went down, after ICE had to go track this illegal down out of the courthouse and tackle him in the rain. Then he's like, hey, Doogie, what's going on? Doogie, answer me, call me. And then left her alone. He's like, he learned that she was a part of this and didn't want to incriminate her because they're BFFs. So then also addressing the Milwaukee Circuit Court criminal case off the record, she said that she whispered it really quietly, but the court reporter didn't include it in the transcript. Prosecutor didn't hear it. Victim's advocate didn't hear it. And also the judge directed this illegal and her lawyer, who we also heard from, out her back door through a non-public jury door and escaped down the stairway saying, I'll take the heat for it. Carl Ashley's already mad at me. Advising the counsel and the lawyer that they could appear by Zoom for his next court date. And I thought that was a really important fact on this whole thing, but we didn't hear much of that in our reporting from the media. And I think that's an important part of intent, because she then allowed him to not come back to the courthouse, gave him special privileges and said, well, if you do come back, presuming that he was going to escape, because if he gets caught, she's like, he's getting deported. But she helped him escape. And so she was presuming that, we'll just continue this case. He won't get caught. My escape plan will be successful. And then we'll avoid him coming back to the court so we don't have to do this whole thing again. So that was the original indictment. She was originally charged by a criminal complaint, then got hit with an indictment to shore that up, and now found guilty. And the DOJ, very happy about this, Pam Bondi came out and said, no one is above the law. You know, it has a nice ring to it. No one can obstruct law enforcement as they carry out their basic duties, says Pam. This DOJ will not waver as our agents and law enforcement partners continue to make America safe again. And this was a good development. I mean, the DOJ really could have used a nice win. It's a nice little Christmas present as the clock counts down. And Cash was also excited about it. Even he's got this fever. You can see why it kind of caught amongst the Democrats back during the 2024 campaign. No one's above the law, they kept screaming as they were indicting President Trump. So Kash Patel now got a little fever over there too. No one's above the law. Feels good. Has a nice cadence to it. So he says, of course, sharing this Fox News article Circuit Judge Hannah Dugan found guilty for helping an illegal alien who was already a multi-time illegal alien, already came into Arizona in Nogales in 2013, was already deported, came back in. That's a felony charge, but never got prosecuted because of Joe Biden and because of our lax immigration system. Then he comes in, strangles, suffocates, beats people. Those victims come into the courtroom, and he still gets special privileges courtesy of the judges. And as soon as ICE showed up, the entire courthouse was like texting each other. Oh no, ICE is here. Help, help. What are we going to do? Because they're all complicit in it. And just like Colton Moore from Georgia said yesterday, maybe it's time to just dissolve Milwaukee County or the courthouse. But here is what went down yesterday. So we've been following this reporting over from Fox 6. They're in Milwaukee, and they're giving us a background on what went down yesterday. So we've been covering the trial. Yesterday, we had closing arguments. We heard from multiple judges. We heard from the ICE agents and more. And that was the rebuttal. Then we got the jury instructions. They've been kind of shifting around. This was on yesterday's page, and then they moved it. But here, the case went to the jury. The alternate juror got let go. They said, thank you for your service. And he said, dang it. And then they left. Now, as we were deliberating late last night, you can see it started in the afternoon and it went way into the night. At 3:35, a note came out. An email from the court said that there's a note for the court. Parties piled back into the courtroom, and the judge announced the question. She said, all right, defense and prosecution here. Jury got a question here. Let me read this to you here. It says they want to see an exhibit that references ICE's internal policies about what ICE has to do before they go get a warrant. Can we give it to them? Prosecution, any objections? No, we can give them a copy of that policy. Defense? No, yeah, no problem, no problem. So the parties agreed on the answer. Judge takes the note, pulls the file, gives it to the clerk, sends it back into the jury box in the jury room. Then an hour goes by, 4:34 p.m. Knock on the door. A court security officer came out of the jury room. Everybody in the court go, oh, we have a verdict? He's got a slip of paper in his hand. What is it? Brings it over to the judge's chamber. Judge comes out, explains. You know, we have another note, and the parties return. Judge says, I'm on the bench now. Here's what we've got, parties. The jury says they'd like clarification about whether if Dugan needed to know the identity of the subject of the arrest warrant. Uh-oh. Does Dugan have to know the name? And did there need to be evidence in the trial that she knew the name, which was Flores Ruiz, illegal alien, whatever, beater and suffocator, whatever his name is. Does she need to know that that administrative warrant is specific for him? And then now that she knows it's for that guy, she's going to escape that guy. Does she have to have that mental knowledge as it relates to the language in the charges? So they're going through the indictment, right? They're going through exactly what we just read. And they're saying, oh, okay, well, a person for whose arrest a warrant and a process had been issued. So did we have to know who that person is? Like, was there evidence that Dugan knew that it was Ruiz Flores illegal? They debate it. The defense says for Dugan, well, Your Honor, if you read that indictment as we just did, that means Dugan would have needed to know that the warrant was specifically for this guy. So she goes up in the conversation between her and the, do you have a judicial warrant? They say, no, we have an administrative warrant. They didn't say who it was for. So they say, well, you need to know that the warrant is for a specific person. That's what the instruction should be back to the jury, which is kind of a higher standard because we don't know if we heard that evidence. Then the prosecution comes back and probably makes the opposite point. Judge says, well, let me think about it. I'm going to go back to my chambers and consider the points on this one. Then the judge comes back out to the bench and says, all right, well, let me hear from you guys again. I got a couple other questions on this thing. Do we have to say that Doogie needed to know the specific name of this illegal? Defense and government are arguing. The judge said, well, seems like we're in a disagreement here. Government is saying, no, we don't need to know the identity. They're there. They have an arrest warrant. It's to arrest somebody. She helped that person escape. That's enough. They don't need to know the name per se. Judge says, well, I've thought about it. And here's what we're going to tell the jury. We're going to say that they needed to know the identity of the subject of the warrant. Oh, no. That's a bad decision for the government. Because that's way more specific, right? The more specific the evidence has to be, then the less wiggle room the jury has to say, well, I think that fits. And there was another little thing that happened. Now, after that comes down, the jury also wanted some pizza. Don't know how long the deliberations will last, but it went into the night and we got a verdict. Now, let's pause here and let's go over to this other thread because Adam Klasfeld was also reporting on this. And when the notes came out, here's how it went down. So a third note comes out and they were asked about whether they needed to know the identity of the subject of the pending proceeding. Okay, government comes out and says no. Doesn't need to be clear. Don't need to have the specific identity in there, of course. The defense says, yes, yeah, definitely have to know the ID, right? Now, again, they're arguing over this, about how it's charged, and says you don't need to know the specific name. That's not an element of the offense. And I think this was for the third note. So let's come back on that one, right? So Adam's also in there, and he was reporting on the facial expressions when these rulings were coming down. And so let me share this little excerpt here. Second jury note. Let's see what this one says. Comes in, the judge enters. All rise, judge enters. Next question from the jury. Jury wants to know, we desire clarity as to whether or not Judge Dugan needed to know the identity of the arrest warrant. Okay, for example, his specific name. They disagree. Now, Masnika, for the defense, says, how could you intentionally obstruct a warrant for someone if you don't even know who it's for? You obviously have to know the name. It can't just be that there's a warrant, because what if it's a warrant for somebody else? Like, what if they were there for someone else and she escaped this illegal? Well, then she wouldn't be obstructing because they were not there for that guy. So the prosecutor, the government, comes back and says, no, that's ridiculous, Your Honor. This is clearly obstruction. It's like obstructing an immigration arrest of an unknown individual on the street. You can obstruct somebody that you don't know. Like, you know they're there to arrest someone. And if you obstruct them from conducting the arrest, that's enough. You don't have to know the subject of their arrest, and you can still obstruct them without knowing that subject. So if you have to know the subject in order to obstruct, that makes the obstruction charge much harder. So he says it's obstruction, even if somebody doesn't know the subject's name. Judge goes back, retires to chamber, and then considers the question. Then he comes back. Now, there was no warrant issued for anyone else, so it had to be for that person. And count one specifically says the name in it. So it has to be in the name. So Judge Adelman then comes out, instructs the jury, and says, yes, they need to know the identity of the warrant. Now, look at this. Dugan, as soon as that came in, prosecutor said, Your Honor, that's ridiculous. You're erroneous. This is not the law. We object. We're lodging that for the record. And if we don't like the outcome of this decision, we'll appeal it, essentially is what they're saying without saying it. So then the judge comes back out and rules for the defense. We were watching this last night. We're like, oh, here we go. They're rigging it right now. It's like 8 o'clock at night and they're all rigging it. So the judge comes back down and says, well, the defendant needed to know the identity of the subject of the warrant. So Judge Dugan needed to know it was Emilio. Soon as that came down, guess what happened? Dugan stands up and smiles broadly. That's according to Adam Klasfeld. He's in the proceeding. She stands up. She goes, perfect. Sounds good. Because there was no evidence of that. Because it wasn't necessary to prove. You can obstruct somebody without knowing the subject of the arrest. Now, Klasfeld throws it into Grok. And Masnika, who said, we want that jury instruction, the defense attorney for Dugan, appears to be in good spirits as well. All right, so last night, they were all just excited as can be. It was about 4:25 our time. Yeah, so as happy as can be. That feels a little early. Anyways, so that was going down yesterday because we were live here right about that time. Anyways, so that's going down. They get a good jury instruction and they're like, great, we're going to get acquitted. And guess what? She got acquitted on one of them. So that goes down. We're all just going here. Oh, gosh. All right. So it's 5:39 back there. The court is still deliberating. They order some pizza. Excellent choice. They scarf down some pepperoni. And then the judge comes back to the bench and says, guess what? 6:49 at night. We need further clarity. The jury sent in another note. Now we need to know the identity of the subject of a pending proceeding. Okay, very similar. Because you've got concealment, you've got obstruction. The government comes out and says, yeah, you don't need to know that the warrant was Flores Ruiz. He leaves, comes back, and says, all right, now it's 6:49. The defense says she can't obstruct a pending proceeding if she did not know who it was for. So then he left the bench again, goes and consults with his clerk. Then he comes back at 7:31. Judge Lynn Adelman said the court, man, I'm struggling. It's 7:30. Everyone's tired. It's like Thursday. It's like they're all thinking about Christmas cookies. Said the court was struggling to determine an answer to the jury's question, but is advancing with to know of the proceeding. The defendant needed to have sufficient knowledge of the proceeding. Okay, so it's like kind of a non-answer. Is advancing with to know of the pending proceeding is enough. Like if you know there is a pending proceeding, in this case, there's an arrest and a warrant that has been issued for the illegal. If you know of it, which she does, then Dugan needed to have sufficient knowledge of the proceeding. Now, what is sufficient knowledge? Who the hell knows? So, all right, like is an administrative warrant and a conversation with ICE that says, hi, we're here to arrest somebody. We have a warrant for it. Is that sufficient knowledge of the arrest warrant and the removal proceedings that have already been initiated? Yeah, of course it is. So the government didn't object. They're like, yeah, no, that sounds good. Yeah, that's better than the other ones. Sufficient knowledge. She got shown the warrant. They're there. There's like 6 dudes all there. Like, hi, we're here. Why? We have lawful purpose. So the government did not object. They're like, that sounds much better, the judge, than the last one. The defense, Dugan's team, made a record of its stance, and they were not happy with that. They're objecting. They're flipped out. Oh, crap, we're screwed on that one. And then here is that third question. Again, so they come back out, third note. They want to know, does she need to know the identity of the subject, of the identity of the subject of the pending proceeding? Feds again say no, of course not. She doesn't need to know the subject of the pending proceeding that she is obstructing for the different count. Defense again says yes. Defense attorney argues, sorry, nope, you have to just go with how you guys put it in your indictment, says the defense, and it's the same answer. And the prosecution, the government says, that's ridiculous. The judge did not need to know the subject's specific name. That's not an element of the offense. Go back into the U.S. code, okay, if you look it up, does it say anywhere in there, and we actually do have it queued up, that you needed to know the name of the person who is charged? Whoever corruptly impedes or endeavors to influence any pending proceeding, okay, that's it, that is being had before Congress can be guilty of this thing. It doesn't say, and if you know the name of the subject, and then you interfere with that subject's case, only then is that sufficient. That's not what the law says. So they go back, and of course they're battling this out. Here is what Klasfeld was reporting. Defense attorney says, well, what do you mean? You have to know the name. How can you impede a proceeding if you don't even know who it's for? It's about notice. It's a constitutional issue. It's a due process issue. Now, the judge is currently in chambers considering all of this, and it is very similar to the last note. So Klasfeld comparing and contrasting them. How much do you need to know about what was going on before you can obstruct or before you can conceal? Judge Adelman comes back out, splits it, says to know of the pending proceeding, the defendant needed to have sufficient knowledge about the nature of the proceeding. Like, that's it. Sufficient knowledge. The prior instruction was about basically the name. This is way lower standard. Okay. It's just sufficient knowledge that they were there for a reason. All right. So prosecution goes, whoo, perfect. Thank you. Defense, not happy. Notice Klasfeld is not reporting Doogie standing up with a big grin on her face. And that's because that's a bad decision from the judge for their case. So That's at 7:31. Jury comes back out at 8:32. The court announced the jury reached a verdict after more than 6 hours of deliberation. Dun, 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 dun. Everyone's going, what the heck? Judge Dugan comes back out. Ladies and gentlemen of the jury, do we have a verdict? We do, Your Honor. Pass it up. They read it. Judge opens it up, pulls it out, and says, in the matter of State of Wisconsin versus United States of America versus Judge Dugan, the jury finds as to count 1, concealment of an illegal alien, a verdict of not guilty. Dugan's excited. Yeah, they're all super thrilled. Oh my goodness, we did it. High-fiving each other. We're going to win. And as to count 2, on the count of obstruction, the jury finds Judge Dugan guilty for obstructing federal agents in the courthouse. And that big fat grin on their faces suddenly gets evaporated like that. Ladies and gentlemen of the jury, this was a long trial. We appreciate you taking the time off during this holiday season. You've done yourselves and your country a great service. You are now dismissed. Woo! And Dugan, not happy about that at all. Their defense team came out and they said, while we are disappointed in today's outcome, the failure of the prosecution to secure convictions on both counts demonstrates the opportunity we have to clear Dugan's name and show she did nothing wrong on this matter. We have planned for this potential outcome, and our defense of Dugan is just beginning. This trial required considerable resources to prepare for and public support for Dugan's defense fund. Oh, you want money now? You're shilling for money? She's a convicted felon. For Dugan's defense fund is critical as we prepare for the next phase of this defense. Busted. So Dugan's team responds. They need some more money and they're begging for it. And I'm sure they'll get some of it from their NGOs and other entities filing and dumping money into her coffers. But that's the verdict that came down. So she is guilty, and we have been waiting very patiently for the verdict forms to drop. This is over from Pacer. Let's see if they have hit the docket as of yet. And no, but we do have a letter from the media that looks like they want a list of jurors or something. Here's somebody wrote this in. Hi, my name is Hannah on behalf of W12 News. I would like to request the jury list of the Hannah Dugan trial and at the finality of the verdict case. All right, so that just got dropped. Now, there's more reaction to this. Todd Blanche posted this saying, former Wisconsin state judge Hannah Dugan betrayed her oath and the people she served when she obstructed federal law enforcement during an immigration enforcement operation. And today, a federal jury of her peers found her guilty and sent a clear message. The American people respect law and order. Nobody is above the law. That's 3 for 3 now. The DOJ and this department will not tolerate obstruction, will enforce federal immigration law, and will hold criminals to account, even those who wear robes and wear them into public hallways to try to intimidate federal agents throwing their weight around. Thank you to the men and women who keep us safe. We will always protect you, courtesy of Todd Blanche over there. Now, there's more on this because we see that the media went bananas yesterday. You can see Mediaite shared this roundup written by this guy called Isaac Shore. He says the liberal legal analyst last night exploded, totally whiff on this case, and they brought out some of the dumbest legal minds in America who for some reason are running circles around everybody. We've got these guys who've not been held in consequence for anything. This is Andrew Weissman, who is on Robert Mueller's team, who's so dumb that he entered his password multiple times into his phone and deleted all of the records on the phone, from our recollection. And this is George Conway, who is widely credited with being the person who facilitated the prosecution of President Trump's by E. Jean Carroll in the Bergdorf case. It was a civil case, but apparently Conway connected E. Jean Carroll, the vagina cat lady who paints her trees blue, who's like a mental case, connected her with Molly Jongfest at a party, who connected her to Roberta Kaplan, who then helped to change the statutes in New York so they could create an extension on the statute of limitations that would enable E. Jean Carroll to bring a claim from 25 years ago that she didn't even remember the date on, to sue the president. She's won like $100 million. Of course, that's being appealed. But they came out and they melted down. And this is a nice roundup here. We know that this illegal called Eduardo was escaped out Doogie's back door. Dugan just got convicted. And they tracked him down. Now, these people who are on the left, like this woman called Joyce Vance, she's a U.S. attorney under Obama, was. That's a scary thought. She immediately wrote on her Substack that everyone is a Nazi now. Oh, no. Nazis everywhere. She writes after Dugan, they came for the judges. She says, when they came for the socialists, I didn't speak out. Then they came for the trade unions. Then they came for the Jews. Then they came for me. And we're all going to be dead now because they're coming after Dugan. You got to be kidding me. This is a Holocaust like remembrance case or something. Are you kidding? Andrew Weissman also came out. Another former federal prosecutor said that Dugan's arrest was an assault on our democracy. George Conway, called the case BS. Judge Michael Luttig, that idiot, who said, we'll never forget. I mean, and I think he should never go down as this quote from him. I wish I queued it up. Remember when they tried to throw Trump off the ballot in, I think it was Colorado? He came out and he's like, this decision is unshakable. It's irrefutable. It's undeniable. And he had like multiple different phrases that he used. And then like 2 days later, the Supreme Court came back and reversed him 9-0. And he's like, But they kept bringing him back on the cables. Then Eli Honig and others, he was very clear. He said, yeah, this is not good. He said, strip the politics out of this. Shout out to Eli. He said, she's guilty, of course, because she is guilty. It's pretty clear. You can't escape illegals out the back door. Now, her conviction is another reminder that the legal media has all been captured. Many of them, in my opinion, are just liars and propagandists. I think that's what these people generally are. They're hatchet men. And like this guy, Weissman, one of the worst out there, in conjunction with Norm Eisen, Mark Elias, it's a cabal of people who are just little minions who can't really think much for themselves. But he was on with Robert Mueller's team, and they were attacking the president. So as long as you do the Democrat dirty work for as long as possible, then you'll get a nice cushy job as a commentator on some crap news station that nobody watches, and you'll get paid millions of dollars for having been that hatchet man. So that all went down. Of course, the transcripts will be released. We're waiting for any of the actual verdict slips to drop, but the court is obviously back in session. I don't know if it's the holidays or what, but they do not have for us the verdict slip. But when that drops, we'll be here to review it together. It's going to be delicious to watch the verdict, the jury form, just saying guilty, baby. Hasn't hit the docket. This is the official federal court docket over from Pacer. And so we'll, of course, keep our eye on that one. But this was a nice big victory for the DOJ. They've needed a little bit of energy in their prosecutions. This is not, one of the J6 scammers, one of the election scammers. This isn't, somebody connected to some assassination attempt or anything like that. But it is a powerful message because this was a judge. And this judge, everybody knows what she was doing. She knew what she was doing. She admitted it. She brought out very high-powered attorneys, did everything she could to not be held accountable because, according to her and to them, they are above the law. If they're acting on behalf of illegal aliens, social justice, if they're protecting our democracy against fascism, then they can do whatever they want because they're on the right side of their own morality, which was really not a morality at all. It's just about political expediency. So now the DOJ scores a big win, and I think that there'll be a reverberation of this decision that hopefully smears across the rest of the corrupt judiciary that we're observing, that, yeah, a jury will come down and they will convict a judge. So don't act like your authority and your appeals to authority are going to escape you, even in a town like this. And we saw yesterday, thanks to you and many of you commenting, explaining that this district is very, very blue. 70% or so for Kamala in the last election, and they still came down, were able to set that aside and actually convict her. And I think that's a positive development because in other areas we've seen the juries nullified the verdicts. The subway tosser out in DC got through a subway at a cop. That's assault anywhere in America. He got acquitted because the DC people hate ICE so much. Their TDS on the brain is so embedded that they can't even think rationally about the application of the law. But this is a good indicator that that is not a condition that is permeated all across the country. And as Kash Patel is saying here, no one is above the law. Do not obstruct FBI agents. Do not obstruct ICE enforcement provisions. And I hope that this is enforced across the board. Many judges in this case were a part of this conspiracy, not to the level of criminality yet, but they were all there. They're all kind of pseudo obstructing. Soon as somebody sees an ICE agent, like the animals in the documentaries, like one little pack rat sees a snake, they all start chirping. They're all like, dup, 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 right? And they all freak out about it. That's exactly what happened in this courthouse. They said, oh no, federal agents are here. They're insurrecting the federal government. They're kind of surreptitiously obstructing, and some are actively obstructing. And so hopefully this reminds them all, top to bottom in this courthouse, you are not above the law. Your states, your sanctuaries cannot insurrect the federal government. There is now an enforcement of the law that is happening. So get on board or go to jail. All right, now, my friends, let's turn our attention to the files that we're looking at getting released today and take a look at what is happening here. It's Epstein. It's Epstein Maxwell files release day. We're waiting for those documents to drop. Todd Blanche says that they're going to be coming out. We'll come back to that. But what is happening in the meantime is Maxwell is filing a petition for a writ of habeas corpus. She is saying, let me out. And what's interesting about this is Maxwell is filing this on her own, pro se. She does not have an attorney who's helping her out with this. And so we'll go through this document to see what is inside exactly. She submitted it in 7 different attachments. And so we'll go through each one. You can see this drop this week. It's a motion to vacate. Maxwell is saying now that Congress and the DOJ and a bunch of people are digging into this, more evidence has come out that shows that she should be released. Essentially, her charges should be dropped and she should be let go and be free. So she dropped these various exhibits. It's really one motion, just kind of separated into a bunch of different parts. But here is what went down. So she gave us all of the table of authorities and the details there. But in her second attachment, we get it starting. She explains, all right, petitioner Ghislaine Maxwell is now proceeding pro se. Okay, she does not have a lawyer here. This is on her own. Now, there might be a strategic reason for her not having a lawyer here. If she's going to make an argument that maybe her lawyer screwed something up, we'll see if she gets there, then she can't have her own lawyers making that about themselves, right? She's not going to have her lawyers say, hey, we're terrible. We committed malpractice, and that's why you have to release Ghislaine. So they may have helped her draft this or create this and just say, hey, blame us, blame your lawyers. That's fine. We're not worried about it. We're not going to lose our licenses or anything like that. Just say we screwed it up, ineffective assistance of counsel, whatever, and then make your claim, and we'll see if you can have more success without us than with us on the case. But anyways, she is pro se, so she doesn't have a legal team who's on this filing. She's now moving this court to set aside and to vacate her conviction. She says, I've discovered new evidence, substantial new evidence that's come from all of these other proceedings, the unsealing fight over the grand jury records, new government disclosures. Congress is dropping images and videos all over the place. She says, I'm exonerated now. This new evidence that came after the FBI and litigation and depositions and all the things shows that my conviction is unconstitutional. I've got 9 reasons why I should be released, and I want my conviction vacated. She writes, I can make these claims under the petition for a writ of habeas corpus under U.S. Code. I'm allowed to do it. This motion is timely filed because the Supreme Court denied my petition back in October, and now I'm here. And here are the 9 reasons why Ghislaine says she is innocent and should be released. 1, this was a big one. Remember this juror misconduct that violated her Sixth Amendment right. So we had this one juror called Scotty David. And when we covered this trial at length, we remember this. And the Maxwell case is such an interesting case because, of course, the allegations against her and Epstein and all of their co-conspirators are horrendous. And they got away with massive amounts of criminality for decades. The problem that we have with the Maxwell case is that it was prosecuted in such a way that it made her the sole bad guy of the entire thing. Epstein was dead. They needed a mop-up operation to clean up all of the rest of it. So Maureen Comey, James Comey's daughter from the FBI, was at the DOJ. She handled the case, prosecuted Ghislaine, and turned this whole thing into a nice little present with a bow on it and said, here you go, case is closed. Now, that was a long time ago when the trial actually happened, and we've now since learned a bunch of other things that show what a corrupt prosecutor, in our opinion, Maureen Comey really was. If she would have actually investigated it and done a good job at the time, she could have found all of the other co-conspirators like a real prosecutor would, like they were onto back when Jeffrey Epstein took his original plea deal back in 2017, I believe. And she didn't do that. So when we go through this case, it's kind of like we're defending a rigged prosecution because it is a rigged prosecution, because they were just trying to make it all go away with this one case, not having to talk to anybody else. So when we say it's like kind of like a rigged prosecution and they were setting Maxwell up, they were 100%. That doesn't mean she's a good person. It doesn't mean that she's innocent of the crimes. It just means that this case was kind of rigged very quickly. We're going to get the grand jury transcripts back from the Epstein and the Maxwell cases. There was like nothing that went into them. Like one witness, 90-minute presentations, a couple of slides. It was a mop-up operation. So when we're going through this and we're kind of agreeing with Maxwell and saying, yeah, this was kind of a joke, it's because it was. And that's not because we have some love or defense of Maxwell. It's because the prosecution was a mop-up operation, and we're learning a lot more about the truth of that now. So Maxwell's coming out, and she says, all right, remember Scotty David? And let me see if I can just grab a quick clip of him on X, because he was an interesting character. No, that's Scott Adams, and we love Scott. We're praying for Scott right now. But that's not who we're looking for. But we got, yeah, Scotty David, man, he's not showing up on a quick search. Yeah, this guy. Yeah, Inner City Press, man. Shout out to Inner City Press, as always. You remember this guy. All right, so this is who we're talking about. And we were covering the trial courtesy of Inner City Press. This is Matthew Russell Lee reporting over at Inner City Press. Awesome dude, great reporting, and we appreciate all he brings to the space. But this is the guy that Maxwell is talking about, Scotty David. This is after, or I think during an interview.
Who wouldn't want to jugular and maybe make...
Okay, not sure what's going on there. Oh, these are the juror blues. Okay, so it's a little video that he made. All right, so anyways, shout out to Matthew Russell Lee. That's the guy, that kind of guy we just showed you at the beginning. That's who it was. You may remember him talking about his experience after the verdict. Now, he was a juror. He gave false answers during his voir dire. He had a history of sexual abuse, and that was the subject of the trial, right? When you're a juror, voir dire, jury selection, you ask a bunch of questions. Have you heard about this case in the news? No. Do you have a history of being abused by, pedophiles? No. All the things. If you say yes, that might make it so that you cannot be a fair and impartial juror because you just have a predisposition to want to prosecute and punish bad people. So all of that came out. Now, after interviews came out, new evidence and sworn statements confirmed that he intentionally concealed his prior abuse and he had actual bias that violates her Sixth Amendment rights. And there's background on this. When you intentionally conceal information during jury selection, The verdict is bad, and a juror's deception means the verdict must be set aside. Now, following the verdict, Scotty David, the guy we just showed you, juror number 50, was given interviews, and he publicly disclosed in an interview, says Ghislaine, that he was a victim of abuse. He denied that during jury questioning. At a post-trial hearing, we brought him back in, and he conceded his public statements. The court denied a new trial, said, oh, it was inadvertent. He didn't mean to do that. He just forgot that he was sexually abused when he got asked that question, inadvertent. And that he did not commit perjury, and he did not lie in an effort to get on the jury. Now, she says that's not true at all. In fact, he did lie. New reporting also explains this, and it contradicts the court findings. Judge, you were completely wrong. He did have bias. At the hearing, Juror 50 came back out and he said that he learned of the sexual abuse questions on the questionnaire during a Daily Mail interview. The court relied on his answer to deny a new trial. She says, and he learned about it in that Daily Mail interview. And he also denied the consequences of this, of revealing this with any reporter. He discussed repercussions about this. He claimed he did not discuss this in interviews, but so in other words, Scotty David lied during the hearing. He told you, Judge, that he didn't discuss these details in his interviews, but he did. He did discuss his abuse with a journalist. He wanted his story of abuse told. It's literally in an exhibit that she's attaching. So you relied on his lies, essentially. His later statements contradicts your findings, and you should reverse on this basis. So juror number 50 also described his abuse. He said it was the same. He said, I wanted the jurors to understand. Yeah, this guy was bad. He explained in his interview after the trial was over, he literally told the media, I wanted people and the jurors to understand from someone else that has gone through the same exact thing. So his sexual abuse was part of the deliberations, according to his own admissions. The verdict is it over. So I've been abused. I wanted to explain to other jurors that this is how it works. So the court determined that his abuse was not so similar as to exercise discretion. But what is important is what the juror thought and felt. And then the juror gave a bombshell interview with juror 50 and revealed that he was using this in the deliberations. Now, at least 2 other additional jurors concealed their sexual abuse in the voir dire in jury selection. Juror 50 made clear he spoke about his abuse after another juror discussed their abuse too. So everybody in there is like, yeah, I've been abused. And they're explaining away the witnesses. In other words, like, well, the reason the witness was coy up there, the reason the witness didn't look credible to you is because she's scared. I know because I was also abused and I'm scared too. And that is undue pressure for the other jurors to say, oh, well, if I find that witness uncredible, then maybe I'm saying you're uncredible too. And it's just, there's undue pressure in there. You're supposed to be nonpartisan, right? Impartial. Now, LOC also confirmed 2 other jurors also discussed their abuse. The court sealed the correspondence from the jurors who wrote to the court, didn't even disclose the content to Maxwell. So the court may have evidence that 2 other jurors lied on their forms. Wild. The court ruled there was not sufficient evidence to prove that they discussed their personal history and the article's hearsay. So the judge is just ignoring the articles where these jurors are talking about their own abuse that was supposed to be answered appropriately in their questionnaire. Jurors were also carefully selected by counsel. None of the deliberating or alternate jurors had answered yes when they got asked if they were victims. Even one biased juror violates the 6th Amendment. Here, there were 3. They concealed their abuse histories, and it's very important to have unbiased jurors. They even talked about this on a Paramount Plus episode, episode 4, talking all about it. So this one juror and others, 2 others, mean that this was unconstitutional. The conviction is resting on a conviction of 9 rather than a full panel, and this must be vacated. So that's point 1, bad juror. Now, number 2, there was also a suppression of grand jury testimony. They say the prosecution concealed Detective Parkinson's grand jury testimony, and they undermined the case. The government's only evidence was a massage table. We saw pictures of that entered interstate commerce. That's it. That's the only thing that entered interstate commerce, according to her. So you have to disclose exculpatory evidence, and they didn't. At the trial, this person testified that he took a massage table from Epstein's bathroom with a shower to prove interstate commerce. However, during his grand jury testimony, it shows he did not identify that table. So his testimony changed. It was a different table in an adjacent bathroom with a tub. Caroline, the sole witness to these two counts, 5 and 6, she described the location of the massage table. She said it was in a bathroom. It was a steam room and shower table, but there was no tub in there. And so he couldn't have properly identified the table. He did not describe collecting any evidence, and he found a cylindrical device in a different room. But this is duplicity. His testimony contradicts itself, and the government changed it in order to suppress the truth. And we were denied the opportunity to even cross-examine this guy about that evidence. The judge, I was going to say, well, why didn't they attack him on that during the trial? The judge said they couldn't. Now, his grand jury statements, if we had seen them, would have undermined the authentication of the massage table, which was the only exhibit that was adduced for interstate commerce to make this a federal case. Failure to disclose the statements of this defense violate the rights of the defendant to have exculpatory evidence presented to Ghislaine. And so since they failed to disclose this evidence, this guy's contradictory testimony, we can show they deliberately suppressed evidence, and we need a new trial. Now, point 3 of 9. Maxwell says, let me out. You violated my due process by allowing the private victims' counsel to act as prosecutors and agents of the government. They say you just gave these other lawyers, these guys, David, Bradley, Seagreed, Jack, and others, who were representing the civil victims, to basically act like prosecutors. From 2016 onward, tons of lawyers are all suing. Documents coming out all over the place. Even Bill Barr admitted in a recent hearing that the investigation into Maxwell was not even led by the FBI. Wild. So here, new reporting reveals that their lawyers, called the plaintiff's lawyers, they say that the plaintiffs instigated this investigation. So the civil lawyers went back and were like, you have to prosecute. So it wasn't an independent decision by these prosecutors. It was public pressure, and it was a political attack. Now, the media was helping them, and they had all sorts of work product and all sorts of other violations that were occurring that was then just passed off to the government. There's Netflix documentaries about this. There was a roadmap, the plaintiff's lawyers. So it was like this incestuous relationship between the civil lawyers and the prosecutors. All the civil lawyers came to the criminal trial. Many were discussing the nexus. They were all working together. There were personal motives to seek to reopen the investigation. So the prosecutor, Comey, and the rest of the Southern District of New York didn't have really an independent basis. They were just kind of buckling to pressure. And many of these civil people reached settlements. Leon Black wanted to pay $60 million to kind of settle this out. And all of this leads to witness tampering. New evidence also shows that the lawyers were coordinating with journalists and the government to create a false narrative. Their lawyers coerce people into giving evidence to support the government's claim. This woman called Carolyn, she said that the FBI directed her testimony at trial, telling her what she was allowed to say. This woman, she's got exhibits supporting this. Churcher, another person, also revealed in another interview after the fact, everybody's talking now, movies are being made, documentaries, Paramount Plus, Netflix. Everybody's talking, saying a prosecutor reached out to her in 2011. Then they held a couple meetings, and the writer and other people were not testifying, but they're just, gobbling up information. The Daily Mail published other articles, people talking about sex slaves, and all sorts of things in that point. Now, the participation of these private plaintiffs is undermining the prosecution. And so we're now moving to dismiss this. It prejudices her because it's he said, she said, and it's not a legitimate prosecution. Now, point 4, Fifth Amendment. Let's see where this one goes. Yes, from 2017 to 2019, the non-prosecution agreement between Jeffrey and the original prosecutors was intended to stop future prosecutions. In fact, this agreement barred the prosecutors from indicting anyone else. It was insane. We've long said that it covered her. It said any potential co-conspirators. Literally, that is what Ghislaine Maxwell is. For more than 11 years, Ghislaine, relied on this assurance that Jeffrey Epstein's original plea deal immunized everybody in his orbit. 4 named women, no charges, and Maxwell. For 11 years, she wasn't prosecuted. Then the DOJ reopened the matter because Epstein died, and they needed to kind of satiate the public who was demanding justice on this. The government confirmed that the earlier investigations was the core of the case against Epstein, and she was included in that protection. Then, apparently, there's no evidence about that deal. Okay, so they're saying that the negotiations included Maxwell. The government, though, didn't want to search for any materials about the non-prosecution agreement. So Maxwell returns and says, that agreement covered me. They say, no, it didn't. They say, yes, it did. Go get the information. Go get the notes. Go get our emails. Go talk to your prosecutors. And they wouldn't give it to Maxwell to make her claim. They say this is intentional suppression. They didn't search for any materials about the non-prosecution agreement and didn't even look. Somebody, Villafania, one of the other prosecutors, lost her notes. Her notes were destroyed, which is illegal. Alexander Acosta, the prosecutor, his internal emails in the key period are missing, covering up why they executed this NPA. That addressed the scope of the NPA. That addressed Main Justice's directives. That is an intentional concealment of material. And failure to disclose any of this stuff is concealment. And you can't do that. So we say we should have this conviction thrown out. If the promises made in the non-prosecution agreement had been honored, Maxwell would not be in prison. And new evidence also has come out. Bill Barr accepted on 8/18 the terms of the co-conspirator clause of the NPA. He said they were ambiguous and you can't understand them to be restricted to Florida. That was the excuse, that the non-prosecution agreement was only applicable to Florida. Maxwell was prosecuted in New York. But even Bill Barr said, well, yeah, the government had a good legal argument and Maxwell's interpretation could also fit. Now, the prosecutor, Alexander Acosta, revealed to Congress that he was not responsible for this. He said, I didn't do it. He remained silent to this for 18 years, even when questioned by the Inspector General. He said, I had no idea why they expanded this co-conspirator clause, but he never stated it was only restricted to Florida. And so his silence on this shows that it actually covered her. He's been quiet for 18 years and hasn't said anything about it. So the non-prosecution agreement included her, is what she says. The new evidence also shows that New York was the driver because they needed to charge her somewhere else, not in Florida. But there was no restriction on where this immunity was limited. It went everywhere. There are multiple examples on the record of everybody understanding this non-prosecution agreement included Maxwell, but they're hiding the evidence of those negotiations because they know it would exonerate her. Drafts of those were given to journalists. All drafts should have been disclosed to us, but they have not been disclosed to us. And the co-conspirators clause was severed from another clause because of a move. So they made changes to the non-prosecution agreement because Epstein was moving around and it should have been broader than just Florida. Now, the government knew or should have known that these address books and other things were not hers. They were using evidence against her that was actually Epstein's. The massage table too. There was an altered chain of custody. Newly released police property sheets show discrepancies in serial numbers or collection dates. The massage table bears a different evidence tag than the inventory list. No contemporaneous photographs exist. There were mischaracterized labels. The Made in California sticker that was used to say this was transported in interstate commerce had no photo on it during the 2005 raid. Wild. So did some agent slap on a Made in California sticker on the table? That sticker was not on there in the original photos. And the list goes on. So the massage table was the linchpin for proving interstate commerce. Without that, 2 counts collapse, and it's completely unauthenticated. Alessi was the sole authenticator for this, and his evidence was perjurious. Jurors made wrong inferences. All the evidence is bad. And so if you rely on unreliable evidence, case needs to be dismissed. So on point 5, the government and the failure to present good evidence means this case needs to go away. Point 6 of 9. Also, they mischaracterized property and financial evidence, saying the asset sheet is showing who owned what, and apparently a helicopter was called Air Ghislaine. But they misrepresented legitimate business transactions. So she was doing lawful business. They misinterpreted it, misleading the jury. There was some co-ownership. There was an account ledger that came in. But prosecutors were distorting summaries. They didn't correct the record. This led to prejudice against Ghislaine. Point 7 is about the expansion of the prosecution. She says, when the jury is asking for explanations of the law, you can't expand the charges. Counts 3 and 4 said that there were conspiracies to transport minors between these years, 94 to 97. Now, at trial, the government came out and said this was a decades-long grooming operation. But it was only like 3 years here. So how can the government come out and say decades long if you only are charging in these counts 3 years? So there was a lot of confusion. Juror 50 revealed the jurors' confusion. They didn't understand what these terms meant. And you never clarified their confusion. So you basically expanded the scope of the case unlawfully. We've got point 8 of 9 saying the government's 25-year delay also violated due process rights. Evidence expires. All this evidence is 25 years old. The government had multiple opportunities to indict. They never did. Pre-indictment delay is a thing. We see that it's hard to gather evidence on very old evidence to use in your defense. Epstein was investigated in 2005. They even were investigating him in 1997. Other witnesses, like Gouveia, they were contacted in 2007. There was an 2008 case. Gouveia in 2011. In 2013, they were investigating Jane Doe's. In 2016, lawyers also met. All of these intervening years were then exploited by these civil people who were just suing to get money. They were going after men with deep pockets in exchange for keeping the identity of those men out of the public arena. Even Bill Barr admitted that post Epstein's death, they were looking for someone to indict someone for trafficking. We had to find somebody. Epstein died, allegedly, by his own hands. The petitioner was not named in these indictments. 4 other women were named as co-conspirators. Maxwell was just a scapegoat. But in addition to that, the government destroyed documents. This prosecutor, Villafana, ordered list of victims and statements literally be destroyed. Acosta, the prosecutor who signed the deal, his emails were lost. The emails would have revealed that emails between Acosta and Epstein and the defense, they were negotiating clauses of this. And the co-conspirators clause was intentionally intended to be global. And I think it was too. Like, that's how corrupt this whole thing was. They gave Epstein a notorious PDF file, a global plea deal that included all of his co-conspirators. You've never seen anything like that. Interviews and notes with victims are missing or incomplete. All the evidence got deleted. And another person called Detective Rick Carey, he was in charge of the Palm Beach investigation. He said that evidence was lost and destroyed, gone. Now we have dead witnesses too. Epstein is dead. So his death denied Maxwell critical documents to defend herself through full flight manifests. Epstein had access to the negotiation history of this deal. It was his deal. Epstein was arguing the intent and his understanding of this at bail and in limine. And if it was accurate, it would have prevented Ghislaine from being indicted. Here's a transcript. And apparently this transcript was never disclosed to Ghislaine, she says. Comment from Mr. Weingarten. He says, we interviewed all the relevant lawyers on the defense side who participated in the NPA, and we were satisfied that we had a very strong argument that every one of those lawyers believed with an objective basis that the deal was global. That is, at the time. The court says, I'm sorry, that? What? She says, the deal of the NPA, it was global. That is, more specifically at the time, the Florida prosecutors and the agents knew of conduct in New York, and that no competent defense counsel negotiating in good faith with the prosecutors would have ever agreed to a deal back then that only protects her right here, but allows her to be prosecuted over there. It's like malpractice. You'd be an idiot. No competent defense lawyer would do that, would have ever agreed to a deal that would allow her to be indicted there if the prosecutors know about that, and they did. So he says, we have come up with very powerful evidence. We believe that Florida prosecutors who were in that deal steered the victims and the alleged victims to New York on more than one occasion because they did not want to suffer the slight of attacks against them. Saying, oh, we can't help you. Go to New York. Don't be mad at us. Go to New York. So we have advanced the ball on this very subject, and we're prepared to completely report to the court as to where we are and what we've done. Yeah, it was intended to include her. They found a way to exclude her by making a jurisdictional argument, but nobody would have signed the deal if that was the truth. Epstein would have given evidence that petitioner was not involved in this criminal behavior or that he wanted to be the sole person responsible for this. Now, Epstein would have also presented documentary evidence that he did not have or live in these locations or have these people even live in there. So he could have come back and rebutted the evidence of these other people, Dave Rogers, Annie Farmer. He could have undercut Jane's credibility. That's a pseudonym. And he's not. He's dead. So can't use him. He would also say that New Mexico, the huge house, did not exist until this woman was 19 years old. This woman, Jane, came out. She said, I was abused in New Mexico at a huge house when I was only 15. He says, no, you weren't. The house wasn't even built. They finished that house at the end of 1999 and the beginning of 2000. You'd be 19 years old. So that Palm Beach also was under major renovation. Jeffrey could have come and testified to these things. And her testimony about the abuse at Palm Beach could not have occurred because it was under renovation at that time. There were no utilities. There was no water. The pilots gave evidence as to the renovation in that time period, but it's factually impossible. Other people called Albert Pinto could have corroborated the status of these properties, and Detective Rick Carey could have come out, and he would have evidence that shows Maxwell's not involved at all, did not sleep in the master bedroom, that those cylindrical objects were purchased by another co-conspirator called Nadia, who's not been charged. She had her own room in Epstein's house, and this guy, this detective, was dead. Another person dead who could have come in and testified and explained all this. Now, the time delay means people die, witnesses die, and they can't remember things to testify appropriately. In fact, Jane even reported she was blackmailed, and her story was used to bolster the case. So all these people are interfering with each other. Jane Doe stated that victims attended a therapy group. She's been talking on ABC about this. Their memories are corrupted, says Ghislaine. This case is too old, and this delay is biasing her fair trial. Now, new evidence also reveals the reason why Ghislaine was indicted after not being named in anything else before is political expediency. They needed somebody. Bill Barr admitted that. He said, we're looking for someone to indict. Now, she was not named in any indictments of Epstein or the second. 4 other women were named co-conspirators, but none of them were charged. None of them were named in any of the other reports. Memory does not get better with time. The government could have indicted the 4 named co-conspirators literally in the NPA, but they didn't. Or any of the 25 men that settled secretly with the lawyers for the plaintiff's complainants. Yeah, who are these 25 dudes who were settling with all the victims? No idea. Bill Barr stated the initial investigation was not led by the FBI. In other words, it was led by the plaintiff's lawyers. And all of this was revealed by Radar Online. And when Villafana directed Edwards to file the earlier case, its sole aim was to overturn the NPA, and Maxwell in the last filing says the prosecutors are exploiting the civil lawsuits. All of that evidence is being passed over to them, and they're running with it. Now, this delay to indict her violated the due process clause, and because of their intentional delay, it's a violation of the Fifth Amendment. And Maxwell's final point, point 9. She says the sentence and the fine is outside the law. The pre-sentence report made recommendations based on erroneous information that the judge then based the sentence on. Probation did a bad calculation. The pilots testified that there's no evidence about an air card. There were non-testifying witnesses. The court relied on Melissa's name and fake settlements. Testimony was unreliable about Virginia and Alessi. She got sentenced for perjury counts that shouldn't have been included because they came from Virginia's case. And the court was making their calculations under the wrong guidelines. Court recognized the error but failed to fix it. And so she's not entitled to these enhancements. By the way, her pretrial confinement was barbaric, said Ghislaine. The court said no, though. The court said, it was nice there. She says, I was held in solitary confinement for 600 plus days. Crazy. She never slept in her assigned bed, not one night. She was searched 7 times a day, her cell and belongings twice a day. So she didn't kill herself or get killed. She was placed on suicide watch for 600 nights, awakened every 15 minutes. Every day was never found to exhibit suicidal ideations, even though evaluated. After 2 years, severe vitamin D, it's hell. Well, you don't abuse people, it's for sure. Petitioner was abused physically and sexually and filed multiple complaints, which is not appropriate. Her sentence is not to be sexually abused. Petitioner was forced into psychological interviews daily, all filmed and recorded. Her legal calls were recorded, couldn't meet with counsel because of COVID. Yes, I know, it's hard. Counsel then filed the letters, and Bill Barr, he said, we have to find somebody, so they did. So she suffered pretrial abuse, which I'm sure many people are not too sympathetic of. But the newly discovered evidence, Ghislaine writes in conclusion, saying, let me out, signed right there by Ghislaine, says this new evidence, referenced above, is such that when taken as a whole, it's a miscarriage of justice. I did not get a fair trial. At least 3 jurors had their own history of sexual abuse, injected that into the literal deliberations. All of that would have never been allowed if we knew. Further, the lawyers and the media conducted themselves in an outrageous manner, improperly concealing evidence, violating attorney-client and executive privilege, denying claims that would have shown clearly certain things could not have happened. If the jury had heard of the new evidence of the collusion between the plaintiff's lawyers and the government to conceal evidence, they would have acquitted us. And so for all of these reasons and more, we ask the court order a vacatur of Ghislaine Maxwell's conviction, an evidentiary hearing, or anything else the court deems appropriate, signed by Ghislaine. So 9 reasons why she should be out, signed by Ghislaine herself. And we don't have any sympathy for Ghislaine or Epstein. What we're upset about is that the DOJ made her the nice little shiny object that everybody could focus on, put a bow on it, and then set it aside. And in doing so, allowed a bunch of other people who were responsible for some of the most heinous offenses in the world to get away with it scot-free. So we're asking for the files to be released. Todd Blanche says they're coming out. Here is what the plan is, and they could drop later today. Here's Todd Blanche himself.
Release. So in these files, are we going to learn any new information about Epstein and people that may have been associated with him?
So yes, so today is the 30 days and I expect that we're going to release several 100,000 documents today, and those documents will come in all different forms, photographs and other materials associated with all of the investigations into Mr. Epstein. And just so everybody appreciates, President Trump has said for years that he wants full transparency, and he wants the Department of Justice to release everything that we can with respect to this investigation and cases. And we saw during the Biden administration radio silence from the very Democrats that are screaming from congressional steps today that we haven't done enough. But guess what? President Trump signed that law 30 days ago, and we have been working tirelessly since that day to make sure that we get every single document that we have within the Department of Justice, review it, and get it to the American public. Now, the most important thing that the Attorney General has talked about, that Director Patel has talked about, is that we protect victims. And so what we're doing is we are looking at every single piece of paper that we are going to produce, making sure that every victim, their name, their identity, their story, to the extent it needs to be protected, is completely protected.
All right, so documents likely coming soon. Not sure what is going to be in there, aside from the things that satisfy the prurient interest. Looks to us, and from Ghislaine Maxwell's filing, that a lot of the most troubling evidence for the people who are responsible for these crimes probably been deleted, was in the government's hand, was in Alexander Acosta's email account, deleted. Maxwell was made to be the scapegoat. Not saying she's innocent by any stretch. She's probably way more culpable than we'll ever know, because they just indicted her on a very narrow set of charges that made it so nobody else would be in the blast zone. Documents will be coming out, but if they're releasing documents, then those documents that are being released are not part of a prosecution, not part of an ongoing investigation, so they're probably not going to be consequential. If they were consequential, they wouldn't release them. So, of course, we want more, and the idea here is that the public gets some transparency, and then the public can connect the dots and say, oh, here is what really went down. But even Ghislaine says 25 men settled with these victims. What were the terms of those settlements? How come they can't tell us those? Oh, yeah, because they are probably joined with non-disclosure orders. So if the victims are agreeing to settle and have non-disclosure orders and agreeing to basically make the whole thing go away, then what else? Was that satisfactory to them? Why'd they enter those agreements if they want further prosecutions or want more justice? Do they want those agreements to be invalid and those prosecutions to happen? Or were they just looking for financial settlements? We will see. Documents should be dropping later today. We'll see if there's anything consequential inside. And of course, we'll be back here to keep our eye on this one. We'll see what the judges say now that Maxwell has submitted her petition for a writ of habeas corpus saying, let me out. Another document dropped, a sealed document placed in the vault. So we'll see if the court lets her out. But she brings up some good points and some good arguments. And if you are having a jury trial, regardless if you're Ghislaine or somebody else, you want to have a fair jury of your peers. You don't want people saying, well, I was also abused. If it was a DUI trial, if your father was killed by a DUI driver and now you're sitting there on a jury for an alleged DUI case, you're gonna have lawyers saying that's a problem. Okay, you're a little too close to this case. Same thing here. So I don't think, honestly, that the courts will indulge a lot of this, because it's already done. Maxwell's done. Nobody cares. There's no political gravitas behind this. Nobody wants to reopen this. No judge anywhere in America wants to be the judge that let Ghislaine Maxwell out. So she is trying. I think her best option is still to seek a pardon or something like that from somebody, but we'll keep our eye on this, see what changes and what the documents hold. If there's anything good inside, we'll be here to cover it. All right. Now, my friends, we got one final segment on the day, and then we'll hear from you. And this is a big one. $9 billion. Some say over half of all the money that went out stolen by the Somali fraudsters and their compadres. You see, this report came down from CBS News, putting the total figure at $9 billion, but that's just the tip of the iceberg here. We've got a full report from the DOJ making the announcement that 6 additional defendants have been charged, 1 pleading guilty to ongoing fraud schemes. And we've got this indictment queued up here. As you can see, these 2 people, Hassan Ahmed Hussein, Ahmed Abdirashad Mohammed, 2 people who stole millions of dollars, and the total number, according to the prosecutors, is way higher than that. And you can see we've got that prosecutor queued up here saying as much as 18 billion, almost an unfathomable amount of money stolen. He compares it to an iceberg, much larger than we can even see. It's like you got to just defund the whole state. All right, so here is what CBS was reporting. 9 billion or more, maybe up to 18 billion. Now busted, under audit, high risk for fraud. He said, I don't make these generalizations in a hasty way, but when I say significant amount, I'm talking on the order of half or more, but we'll see. When I look at the claims and data and the providers, I see more red flags than I see legitimate providers. This came from Minnesota Department of Human Service Inspectors General James. He said the amount of fraud that's occurring here is shocking. If there is Medicaid fraud, the state should be given the information to DHS so they can shut the door on those payments. We're working on this aggressively, but the fraud in Minnesota outpaces that of other states and puts services at risk for the people who really need them. The magnitude cannot be overstated. What we see in Minnesota is not a handful of bad actors committing fraud. It is staggering industrial scale fraud. The entire community. All in on the grift. Now, the investigators' new findings may bolster Trump's claims, that Minnesota is a hub of fraudulent money laundering activity. $9 billion, we should see multiple people in jail for that. It's not like a mistake. It's a hub of fraud. Tim Walz is leading it. Trump has capitalized on it. It's not. How did he capitalize on it? He's calling them out for stealing billions. More than 90% of the people charged in the fraud cases were Somalians. Walz says, we love our Somalians because they probably pay us some of that stolen money. Let's take a look at the DOJ, see what they said here. It's disgusting. 6 people charged federally with participating in schemes to defraud. And you know what they stole from? The autistic. The autism funds stolen. The Somalians. They're not autistic, officially. 1 defendant charged in the early intensive development autism scheme pled guilty today. In the autism fraud scheme, this guy, age 27, has been charged by federal information 1 count of wire fraud. From late 2020 through 2024, they defrauded people with autism spectrum disorder, stealing money from the autistic. Now, Star Autism, apparently, he used Star Autism to carry out this scheme to defraud the program. This program purported to provide necessary one-on-one therapy to children with autism. In fact, Star Autism employed unqualified individuals as behavioral technicians, and these technicians were 18 or 19-year-old relatives. No formal education, no training at all. So they needed children who had an autism diagnosis and an individual treatment plan. So what did they do? They approached parents in the Somali community to recruit their children into autism. If the child did not have autism, they worked to get them to have autism. As a recruitment tactic to drive up enrollment, they paid monthly cash kickback payments to parents who enrolled their children there. The amount of these payments was contingent upon the services that the kids received. The higher we could grift your kid like cattle, the higher the kickback. Parents are like, great, I'll send my kid over here. They'll get some education. Maybe not even send them, just enroll them and just send them to the public schools. His partner submitted millions of dollars worth of claims for reimbursement on behalf of Star Autism. Many of these claims were fraudulent, and they amounted to $6 million in this one case. Among other things, he used that money to go buy a semi-truck, and he also spent more than $200,000 in Kenya. Sent it to Kenya. This other guy, age 28, it's a her, Asha. She stole $14 million from the autistic. Hassan also charged with participating in the Feeding Our Future fraud scheme. She got almost $500,000. Others pled guilty. Now there's more. In July 2020, there was a housing stabilization program. In 21 alone, this program paid out more than $21 million in claims and more. These people, Anthony Jefferson, Lester Brown, they've both been charged as well. They registered LLCs. They said that they were service providers. They said, we'll provide shelter to Section 8 housing. We call ourselves the housing guys. Then they hired family members. The employees created fake client notes. So they're like creating fake profiles. They invented fake employees. They didn't keep any client notes. They got $3.5 million and more. It just keeps going on, all over the place. Another $750,000 here. Another one from Kamil Salah, age 26. 4 counts there. Salah was supposed to be providing housing consulting. He didn't. He stole money, $1.4 million, $150,000 in cryptocurrency. It just keeps going. The list goes on and on. The whole system is fraud. And this is interesting. Now, according to Homeland Records, Ultimate Home Health Services submitted claims for reimbursements for over $1.1 million in funds. During that time, they had 13 clients. Another individual with severe mental illness was found dead in his apartment. But records show he was receiving services. Wow, so great service. You're now dead. They billed 12 hours a day. All of this is fraudulent. So here is the indictment, courtesy of the Minnesota prosecutors. Here is what one of them looks like. What did I do? There it is. All right, so here it is. Says the defendants in this case, these two guys, Hassan and Ahmed, they carried out a scheme to defraud Minnesota. The program was designed to help people with disabilities and addictions. Sick. But rather than actually provide that help, they misappropriated millions of dollars that were intended for those people. In July 2020, Minnesota became the first state in the country, to offer Medicaid coverage for housing stabilization services. So healthcare for housing. The housing stabilization program is designed to benefit people, seniors and people with mental illnesses, substance use disorders, find and maintain housing. And I used to speak at treatment centers and basically halfway houses where people were living, and to steal from these people because you're Somalian is sick. The program permitted reimbursements for 4 kinds: housing consultation, housing transition, housing sustaining services, moving expenses, and more. The program had a low barrier to entry. You just have to be 18, submit some paperwork, undergo a background check, do 5 hours of training. You don't have to have a license or anything. Very low barrier to entry. All you got to do is apply. They're like, sure, what do you need? To bill, a provider needed to only submit the names of the services. Minimal records required. They just hand the money out, our stupid government. It cost about $2.6 million annually is what they said. DHS predicted $2.6 million total. That was inaccurate. In 21 alone, $21 million. Then it went up to $42 million, then $74 million, then $104 million, and in 2025, $61 million, because who doesn't want free housing? A federal investigation revealed that many of these people are fraudulent. They acquired the names of program-eligible beneficiaries. They went to addiction centers and spoke there, and stole their names. They then used those names and information to create fake reimbursement claims. They stole. Now, these two guys did it. One guy created Pristine Health. The other guy created another one. And they were all working to enroll people in this program. They were paid with Medicaid dollars. $750,000 in fraudulent claims were submitted. Why? To steal the money. Fake and inflated bills. and submitted false claims. They received taxpayer money to which they were not entitled. Submitted paperwork that this is how they were operating things. They styled themselves as program coordinators over here. They said we were consulting with people. To further expand their operations, they created another entity called Company One. Don't know why they won't tell us the name of that one. They marketed their services to Pristine. They called it another entity called Brilliant Minds. They called it a marketing company. They were growing their clientele. Yeah, more Somali fraudsters. They wanted a new list of clients every month. And they sent an email. Do you know if you have only one client submitted, it covers a whole year subscription from the US? Just trying to find addicts that they could put on the payroll. But in reality, they didn't actually provide any services. They shared frauds of their, they shared the proceeds of their frauds with all sorts of people, traveled everywhere, London, Sydney, and elsewhere. And here you can see what they did. Emails sending back and forth. We demand they forfeit all of these things. And they have now been indicted. So it's shocking how fraudulent everything is. And for some reason, you know, many American citizens who are like on Team Blue just sit around and they're like, well, they need it. You know, this is America. They need humanitarian help and support just like anybody else. And so don't be a bigot, even though that money is being stolen out of their mouths. Do they not know anybody who's a citizen, who is honest, who might be able to use some addiction services or housing provided by their fellow man? Instead, it needs to be stolen by Somalians. So here, Andy No posted this. He said, federal authorities are raiding the offices of another one, Somali-owned Ultimate Home Health, in their investigation into this scheme. Somalians have stolen hundreds of millions. Now that's up to billions of dollars. Billions with a B. All right, so loading up out there. The whole program should just be shut down. I mean, they shouldn't get $1 from the feds on anything until the problem is fixed. Shut it down until we can figure out what the heck is going on. Now, CJ Pearson, shout out. He shared this clip from yesterday where the prosecutors came out and explained the depth of this Somali fraud.
I spoke in the fall about the iceberg I saw ahead. Something's fraud that's much larger than what's been visible to the public. When I said that, it wasn't hyperbole or rhetoric, it was a warning. And today I want to talk and I want to show here a sense of what that iceberg looks like, because I think people deserve to know what that is and how big this problem is, because we can't solve the problem until we grapple with the size of it. So the Center for Medicare and Medicaid Services pulled the claims data for these 14 programs dating back to 2018. And those 14 programs in Minnesota have cost $18 billion since 2018, and more than $3.5 billion in 2024 alone. So that's a sense of the magnitude of the problem. These are the 14 Medicaid programs, which is just a part of Medicaid, these waivered services that have been flagged as having issues with program integrity and fraud. Now, I'm sure everyone is wondering how much of this $18 billion was fraud. That's it's not the $1 million question, that's the $18 billion question. The answer is far too much, and the task ahead of all of us is not only figuring out how much of that money was fraud, because we know
a lot. So over half is what he's quoted at in other articles. And the people who, it's not just the people who are the final recipients of the money who should be prosecuted. It's the people who enabled it. It's the politicians who have a duty, an obligation to not allow this stuff to happen. Okay. When you take office, one of your jobs is to make sure that it's functioning with integrity and that you're making requests that are legitimate. You can't Fannie Willis $18 billion out of our country because you love the Somalians. It's sick. I hope people go to jail for it. If we lived in a serious country, there'd be a lot of people in jail for it, not just the people who are at the final receiving end. There were people who were handing this money out, who were getting kickbacks, who also need to be indicted. And hopefully this is the start of something big. We'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do. All right. What a lovely Friday it is, my friends. Thank you for joining us a little early today. Members, stick around. We're going to debrief and have an after party today, but let's see what you say about all this and more on this amazing December 19th Friday, baby. Christmas next week. Oh, how excited we are. Oh, we went to a great candlelight for string quartet, and it was beautiful last night. Here, let me show you a little bit of this. This is what we were doing last night, and it's a string quartet. Here's what it looked like to get in the holiday mood. If I can rotate my screen, let's try this. It was great. So we're very excited for the holidays, feeling extra Christmassy after that event last night. It was beautiful. But now, my friends, let's see what you say about all of this and more. Guilty, guilty, guilty. The backdoor Judge Dugan, now convicted. 1 count. She's going to be appealing it. It's going to be fun. But she's a convicted felon. Uh-oh. SPG 525 Smith, what's going on? Welcome aboard as our newest supporter. We'll see you in the after party. Stick around. We should automagically transfer you over. Doug Rockhold, you too. We'll see you in a minute, my friend. Thanks for joining up and becoming a supporter. Hey, thanks for the gifted membo, says Will H. 11 months. Have you been stringing together gifted membos for 11 months? Man, that's amazing. Love that. Will, thank you for that, my man. Thanks for being here. Almost a full anniversary to us. Griffey, what's going on, Griffey? 2 months as a membo, says it's awesome. She should do 180 days in prison. Yeah, I mean, she could get up to 5 years, but is the judge going to give her any jail? She's a first-time offender. I highly doubt it, but it'd be nice to see. Griffey, what's up? The Savage, good to see you. Hey, regarding Dugan, and here I was thinking we were getting tired of winning. Nah, still feels great. Not a reference to her backdoor. No, definitely not. We're now done referencing her backdoor. There's a lot of backdoor Dugan going on here. You know, it's bad visual. So, yeah, it does. It's good. We're happy to see that because we've had some not so good ones with Latish and Comey and some others. But this is a good one, the Savage. We're happy to see justice done. She did it. She knew she did it. She admitted she did it. All the other judges knew she did it. They were trying to get away with it. Like, you know, kids who stole that extra cookie before dinner. Hot Soup, what's going on? Welcome aboard, Hot Soup. Amazing, man. Shout out to our new membos. Very excited to see you in just a few minutes and see what else is cooking out there. B.H. Williams says, but she did know the identity of the subject of the warrant. Didn't she ask to see the warrant? Yeah, I think so, but I don't think we had any, we didn't have any let me finish your comment. At least the chief judge did because he asked for a copy of the warrant. Yeah, I think they made a physical copy of it. I just don't think that there was testimony in there that the ICE agents or the FBI agents said to Doogie, we're here for Ruiz Flores. They didn't say that unequivocally. They showed the warrant. Maybe she looked at the warrant, didn't read the name. There's no evidence that she knew who that person was specifically by name. So that's why it makes it hard to convict her, because you have to kind of get in her brain. Did you know it was for him? And did you know who he was? And all of those things. That's why when the instruction came down, we all go, oh, great, here we go. And she was not convicted on that one because it's a harder thing to prove. Just Rhonda, what's up? Just Rhonda, bringing in 20 new membos. We love you, Just Rhonda. Thank you for doing this. And new membo friends, we'll see you in just a few minutes. Madeline West is here. Fiery Red Podcast, welcome. Amelia joining in. We got Miss T here. Lion Dog, what's up, Southpaw? Gale Force Happens. Saintly Beginnings, John Smith is here. Suzanne Tate, welcome. Anna B in the house. We got R. Marfil, what's up, Vapor Valley? We got Midwesty in the house. Niche Org. Cheryl Burke, welcome. Nemo Los Angeles. MS Powered. We got User, welcome. All courtesy of Just Rhonda, a.k.a. Sassy Gemini, in the house. We got Trump and the purveyor of fine emojis. Trump Sword, what's up? 6689 in the house. Trump's Sword says, need to look up the offense level and the criminal history to input into federal sentencing guidelines. The PSR isn't available yet. I'm overjoyed. A Milwaukee jury convicted. Dang. Maybe we'll vote in a Republican governor. Good to see you, Trump Sword. Yeah, so federal sentencing guidelines, like they have these charts, you know, and you have enhancements and like mitigation, and you can move around to see what the penalty will be. Then they do a PSR, which is a pre-sentence report, where Doogie will go meet with a representative and then get asked a bunch of questions. So when it comes to sentencing, she's now been convicted of one count. She'll be sentenced, and then the conviction will be, you know, more formal. But the process of a sentencing is the defense will make their pitch. She should get probation. She should get no fines, 1 year probation, nothing else. The prosecution can come back and say, we want 18 months. Maybe they will. And then the PSR will give the judge kind of a full breakdown of her criminal history, her, you know, mental capacity, like is she capable, all the things. And then the judge will have 3 reports, one from the court and probation, one from the defense, one from the prosecution, and then make a decision on what the penalty should be. So the fact, though, that they convicted on 1 count is pretty dang amazing. The Savage is here. What's up? Hey, regarding Dugan, we got that one, the Savage. Thank you for that one. Very nice, Dono. Gauntlet KI says, can Congress release ID of settlement with victim? I don't think that's a part of the order or a part of the Epstein Transparency Act. And I don't think so, because those are private parties. It's a private 25 dudes, private victims. And Congress is just demanding that the executive branch release the files. So in other words, Congress can't force 2 private parties to do something after it's been done. You could say that's like an ex post facto law or something, right? Oh, now you have to unseal it. Well, what jurisdiction do you have to force 2 private parties to unseal anything? I don't think so. I think that they would just have to say, if it's in the government's possession, then they can order the executive branch to do it, which is basically where they've gone. We read through that act. I don't think it had anything to do with the private parties. But yeah, why would the victims enter into a settlement that has non-disclosure orders if they want people to be prosecuted? Were they just taking what they could get? So now they can't testify? I mean, you can't contract away a crime, really. You know, so you could say that the crime would supersede the civil stuff. But they didn't admit to any crimes. They're just settling, you know, allegations. So that's my point. It's like these victims are not helping out a lot, unfortunately. Whoa, man, what's up? 8 months as a membo. Hey, wonder what the real autism stats are. Merry Christmas. Merry Christmas, whoa, man. Yeah, I don't know. You know, the autism thing's a wild one, because some people are just saying that it's basically more, you know, it's always been around. We're just noticing more. That's why autism rates are going through the roof. We're just, identifying it. So that's why, like, the question is, why are rates rising? Why does it seem like autism is growing? Is it food? Is there actually more autism? Or are people just saying that this qualifies as autism when historically it didn't? So that's what's expanding the numbers. But I don't know. I mean, if you see what just happened in Minnesota, maybe those are part of the numbers. Everybody's like, wow, look at all these autistic kids everywhere. It's like, no, it's just Ilhan's brother running around. LZ, what's going on? Rob, are you planning to go through the thousands of fraud cases coming out of Minnesota? Yes, everyone. If so, I admire your work ethic. Carry on. That's right. All 1,000. We're going to account for every stinking cent that these Somalis stole from us until all the billions are accounted for. How much of those fraud dollars went to Tampon Tim? Yeah, or to Mayor Frey, or to Ilhan Omar. These people get millions and billions cumulatively. And you think they're not just buying off politicians? And then Jacob Frey goes and shoves in, like, I don't even know, cat or dog. I guess they're eating the cats. They're eating the dogs. So they just fry them up, put them in like an undercooked bowl of mucus. And they're like, here, Jacob, eat some of this. It's good for your culture. So yeah, I bet a lot. That's why they cover for them. It's like, we love the Somalians. Why? Because you got 1% of $1 billion back into your campaign. Hey, J-Mac, what's going on, J-Mac? Rob, Merry Christmas. Will Dugan lose her retirement, be disbarred, and removed due to the conviction? That's a great question. Another one from LZ. Will Dugan get disbarred? So, yeah, a felony conviction's pretty big deal. Now, I've seen attorneys absolutely get disbarred for felonies. I've seen attorneys not get disbarred for felonies, but be on like a probation, be on like hiatus for like 3 years, and you got to make sure you don't have any problems. So I don't know exactly how Wisconsin is, like what the status is there. But if it's like, if Wisconsin is like Fulton County or Georgia or like New York, maybe not. But if it's a real place, I think she'll probably be suspended, at least, like at minimum, be suspended pending an investigation, or maybe on probation, pending her appeal, kind of on a probationary status. So they're parallel tracks and parallel processes. Like, I don't think that again, I'm not licensed in Wisconsin or have any interfacing with the state bar there. So I'm not exactly sure how they'll handle it, but that's a great follow-up question to dig into. But they're parallel tracks, right? So your criminal conviction will have collateral consequences. So yes, you'll be convicted. Yes, that conviction will have to, result in a fine, criminal probation and a penalty. But there are collateral consequences for other. So like, for example, if you get criminally convicted of a DUI, one collateral consequence is your driving privileges might have an impact to them, right? It's like a license. So your driver's license might be impacted, but you also have due process when your license is being suspended. So you can go challenge that with your DMV and have a hearing on that. So it's not automatic per se. So for example, the bar now, so I would imagine she would have to disclose voluntarily to the bar, dear bar, and judicial, committees, that I have got a felony conviction that has just been landed. It's pending, sentencing. It will be formal on the record. And now you're on notice. So then they can begin their investigation, and then, the due process for her ability to practice law will be in jeopardy pursuant to that, process. But yeah, it's big. Like, a felony is big, and misdemeanors are also big. You also have a volitional duty to disclose this stuff to the bar. Yeah, LZ, we'll see. We'll see what Wisconsin does. And then you can also like have a license suspension. So like in Arizona, if you're suspended for 6 months and a day, you got to retake the bar exam and kind of get relicensed, the whole thing. It's a lot. So we'll see what happens. But great questions. We'll follow up on that for sure. TX40, because I don't know what's going on in Wisconsin. But again, like, Fannie Willis can do whatever she wants. She's not in jeopardy. She can lie on the record. She can come in and misappropriate $700,000 of money. She can do whatever she wants, and she's not in jeopardy because the bar and the people there will defend her. Same thing with Letitia James and Alvin Bragg. The institutions will protect their players. So I don't know if Wisconsin's going to be like that. Like, even if she had a felony, they might just say, well, she's got no priors and she's appealing it, and so we'll just kick this down the road for a little bit. Here's one from Rumble. Shout out to TX47 watching on Rumble. What's going on? Hey, Rob, something I don't see much of is reference to, quote, federally registered official signature. Please look that up, and the penalties attached to fraud and malfeasance in the use of an official signature. That's interesting. So hopefully when I look that up, I get a little more context around that. Are you talking about elections? Yesterday, TX47, if you missed it, we talked about Fulton County admitting that they did not have proper signatures on their election results. Admitted. 300,000 plus. Absolutely insane. Hey, the Rubos are here. Look at this. Rob, Alexis, and the Watcher fam from the Rubos. Man, the Rubos. Shout out to the Rubos over at rubosaltshop.com. And they have a great book out called My Father's Miraculous Rock Soup on Amazon. Great photos. We love the Rubos. Merry Christmas to the Rubos and everybody here. Thank you, Rubos, for sending some love to all of our friends here. What a lovely day, my friends. Thanks for sending those in. Thanks for supporting our work. Thanks for becoming members. We're going over for members only after party time. right now. But before we do, let's say hello to our friends on X. Neuro D, what's going on? Neuro D in the house says, check out Rumble too if you want to come hang out with some amazing friends over there. We have some amazing friends. Ray Dev, what's going on? J-Ma in the house. We got Trebly Chef. Left Coaster says, is Backdoor paying for her lawyers out of pocket? Left Coaster X. So we just read from her defense team that they're trying to raise some funds. So yeah, I'm sure she's paying for it, but she'll have a bunch of lefties who are piling in to help her raise some money. I'm sure of it. Hey, Conservative Black Brilliance. Man, shout out to Conservative Black Brilliance in the house. Great to see you here. At Lee 68633 Lee, shout out. He says, trans or domestic terrorists. Perfect. He says, finally, a win. Good to see you, Conservative Black Brilliance. Great to see you over there. And Neuro D, great to see you. Thank you for shouting out our Rumble link. And what a lovely day it is, my friend. Of course, we are now going over to after party time with our membos. So if you're a YouTube membo, hang tight. It should automatically transfer you over to our new stream. Locals friends, hang tight over there. If you're watching on Substack, hang out over there. We'll be right back over there on Substack too. Links in the description below. We're also doing nice notes on our shows over on Substack if you want to check that out. But we'll pause here for the day, my friends. Happy Friday. Of course, members, we will be back tomorrow for our Saturday members only morning stream. And then next week, we'll be here Monday, Tuesday for sure. Then we're traveling down to do some Christmas mass with the family on Christmas Eve. And then we're traveling to DC next week. So right after Christmas, we're hopping on a plane, heading out to DC to go scope out the town to see if it is livable. So we'll figure that out very soon. So we will be back, my friends. Thanks once again for joining us this week. We had a great week. We covered a lot of stuff. We got a guilty verdict. That's always good. And it's always a pleasure to be hanging with you, going through the news as we save America together. So we're excited for much more to come, but we'll pause here for the day before we wrap it up. Want to thank our amazing mods and meme smiths in the house, of course. K-Bean, Carrie B, Muffin Rando, mod of the fort down for us. We got Neuro D, Janek Dog Digger. We have Gigum, Just Rhonda, Elliot, our friend John in the house, and Muffin Rando, along with Donut Mind Me. Mod in the fort down for us, keeping things beautiful and nice and orderly. But now it's members only time. We're going to hang out for a little bit longer. We'd love to have you come join us. But if not, I hope your Friday afternoon is amazing and your weekend is outstanding. And I hope you come back on Monday or on Saturday to join us again, because we will be back here to close out the year. And we'd love to have you join us as we do. Thanks for subscribing. Thanks for hitting the like button and all the things. And until we're back, I want to wish you a beautiful day. I hope that this weekend you're out there finishing up all of the shopping, wrapping everything nice and beautifully, and restoring, rejuvenating, and returning to get back into it again. We will be back here to Monday, and we hope to see you then. And in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful weekend, my friends. Merry Christmas. We'll see you right back here on Monday. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. We brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. with nothing to hide. So drop a like and don't forget to share, and bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the script.